Today's session is going to be on part one of a two-part series presented by Mary Gigante of Waldecker Coyne, a law firm here in Northeast Ohio, on legal documents. And the first session in legal documents is a good corporate practice in protecting the company value. Legal documents are some of the most important things that you need to get in order, regardless of when a ownership transaction is going to take place. It's actually just good business practice generally. So we're very pleased to have Mary here with us today, and I think without further ado, I'll turn it over to you.
Thanks, Chris. As Chris said, I'm going to speak today about legal documents and not really focus on succession planning or business transitions, but just everyday good legal practice and legal documents, and what should a company have in order to really protect itself from a company standpoint and protect its value and resources. And in the value and resources, obviously with any company, one of the key resources are its employees. So we'll talk about that as well. So I'm going to start very basic. And the first thing is the company properly registered? And so what you want to make sure is that your company is in fact registered with the appropriate state agency. Typically it's going to be your Secretary of State filing, where either your charter, your organizing documents will need to be filed. You want to make sure that those documents are up to date, that it has a correct address, that it has a statutory agent. And a statutory agent is the person that is on these documents that lets people know who to contact if there are any legal notices that need to go out, tax notices that need to go out. And here in Ohio, if you do not have a current statutory agent or a current good statutory agent address, the Secretary of State can cancel your charter or your articles, which obviously then means that you're not really operating in a corporate form or a limited liability company form. So it's important that you check every few years to make sure that the Secretary of State does have you properly registered. And again, you can go on the Secretary of State website and actually search your own company to make sure that that is happening. Okay. The next thing I'd like to talk about are trade names or trademarks. If your company has a lot of value in its name or a logo, you can file for a trade name or a trademark to protect that company identity or logo. It can either be a state filing or it can be a federal filing. And if you do a state filing, then you're just protected within that particular state. If you do a federal filing, then you're protected in the U.S. Anytime you do a trade name or trademark filing, some of the questions they will ask you is the date of first use. So even if you don't necessarily file right away, you can go back and claim your date of first use of that name or logo. And then you'll have to provide some examples of the use. So whether it's your letterhead, some advertising material, you'll need to supply usually at least 2 examples of the use of your trade name or trademark. And again, it's just to provide additional protection towards the company name or the company logo that you have now built up value in. Okay. Next, let's move over to if you're practicing your business in a corporation, then you want to make sure that you have bylaws, or in Ohio here we call these code of regulations. And the purpose of the bylaws is that it's to provide overall structure and rules for the company. So some very common items that you will find in bylaws include the rules for shareholders meetings, who can attend those meetings, how they can be called, what is a quorum, how many votes does each person have? Is it per person, or is it based upon the number of shares? Your bylaws will also state the number of directors and what the qualifications are for the directors. It will state director duties. What are some of the director's duties? What are they responsible for? It will also talk about the directors' meetings. When can those be called? Quorum, who has to attend. At the directors' meetings, they typically will nominate and appoint officers. So your bylaws may state the officers, which offices are actually going to be held. For example, you can have president, vice president, CEOs, secretaries, treasurers, assistants, etc. State the qualifications. It'll state what a general description of what those duties are of each of those officers. It will also state if committees are permitted and what the makeup and the composition of those committees are. Your bylaws should also state what the shareholders' rights are as far as their share ownership. So, for example, can they freely transfer their shares to any third party, or are there certain restrictions on those transfer of shares? And your bylaws will state, again, those rules. Bylaws will also state whether or not they can in fact be amended, and if they can, how they can be amended. And typically your bylaw amendments are a supermajority action. Your bylaws may also state if there's any other types of decisions that would require a supermajority.
Mary?
Yes.
We have a quick question. Is it a lot of times when we talk to small business owners, they see a lot of these formal type things they have to do as just in many ways, especially for the smaller companies, as ways for lawyers to charge them additional fees, and they don't necessarily think that because they're so small they need to worry about these things. So I guess my question is twofold. I'm assuming that they are pretty necessary and you shouldn't try to skimp by skipping some of this stuff. And the second is, are they relatively easy? Are these bylaws and the registering trademarks and trade names relatively easy things for an average business owner to do? Does that make sense?
Yes. Okay, let me answer that. The first part of your question, with a small company, are these documents necessary? If you're a single owner, yes, they are necessary, because what they afford you is they afford you the fact that you look like a corporation and you're acting like a corporation. And so that's going to help you build up liability protection, because if somebody were to sue you, and one of the things they would sue is they would try and sue you personally and say, well, you're not acting like a corporation. These are things that you can point to say, yes, I am acting like a corporation. I'm incorporated. I have bylaws. I have these documents in place, and I'm acting like a corporation. Even though I'm the only owner and you just really see me and my business, I still am acting and following the corporate formalities and the corporate format. So you want to do this even if you're a single owner for liability reasons. It gives you just more evidence that you're acting as a company. If you have more than one owner, two owners, you want to be able to point to, if there's an argument, you want a document that you can point to help address questions. For example, I don't like what my business partner is doing. What can I do to rectify the situation? Can I throw them out of the business? Can I take their shares? Well, these documents at least put a framework in place. And again, there is some general language that you will see in many bylaws, but as you add shareholders or as you add people and you want to customize it to your company, you can do so. So from those standpoints, it's important to have these documents. And then I think, Chris, your other question was, how easy is it to have these things done? If you're doing your trademark trade name filing, if you're just doing it with the state, it's very simple. It's basically a one-page form. You can get it off of the Secretary of State website. I think the filing fee is under $100, so business owners can do that themselves. If you're looking to do it from a federal standpoint, you could do it yourself. I believe that's the filing fee there is a couple $100. The forms are a couple pages. You do need to make sure that you have good examples of how you're using those things, but you could do it on your own. But I would say most of our clients on the state level, they'll do those, but when it gets to the federal level, they'll involve an attorney just to make sure everything's done properly and can kind of trace it through the federal process.
Okay, makes sense. And I realized after I made the initial comment that I don't generally share that opinion of lawyers, but
well, it's a valid point, because especially if you're starting a business, you need to be very mindful of where your dollars are going, because it is expensive to start a business. So you want to make sure you're making good choices.
Right.
So it is a valid point. But again, a lot of what I'm suggesting here is just building up liability protection, building up protections for the company, because from what I see, I would rather be able to control the situation, put documents in place, create liability protections, than on the back end having to litigate, being in arguments, being in fights with whether it's the employees or with co-owners, and paying huge legal fees for litigation, or just deciding that I can't afford it and having to walk away from some value there.
Right. That's generally what we tell business owners, that the upfront cost may be a little bit more than you may have been thinking, but they provide you with a high level of protection further on down the road.
Right.
So.
Right.
Okay. Great. Thank you.
Right. You're welcome. Also, in the bylaws, one of the other things that you would want to consider is when you're looking at the number of shareholders you have or the number of directors you have, if there's an equal number or an equal ownership, how are you going to address the possibility of deadlock? Because if you have a 50-50 vote, you're not going to have a majority. And so what are some of the ways that you can address that deadlock? One of the ways is you could go to arbitration. You could name a trusted advisor or third party to break the deadlock, or you can put a provision in there where if the two owners typically have such an impasse, on the whole decisions, that you can basically, one of them can make the other one an offer to either buy the other out or to have the other buy them out. And the purpose of that is if you're making the offer to somebody, because you just can't work together, and so one of you needs to walk away from the business, and you don't want to have litigation. So one person is going to make the offer, and it's going to be a fair price, because as the person making the offer, you don't know if the other person is going to accept and be paid out, or if they're going to accept and pay you out. So that's a way to make sure that the price is very fair. So it's kind of like playing Russian roulette, if you will, where you're going to pull the trigger to get one person out, but you don't know if it's you leaving or the other person leaving. So again, those are just some ideas to address deadlock. But again, if you have two shareholders and you're equal ownership and nobody has a clear majority, you want to be able to address how you're going to handle the deadlock before a deadlock happens. Because once a deadlock happens, then you're basically left with litigation. Okay. Then let's move over to a limited liability company. And more companies are moving into this format, a limited liability company. They are relatively new creatures compared to corporations which have been around for hundreds of years. But a limited liability company is more flexible than a corporation, really from a tax standpoint, because a limited liability company can elect to be taxed as a corporation, to be taxed as a partnership, or to be taxed as a sole proprietor. And also with a limited liability company, it is under state laws affords limited liability, but you don't necessarily have to follow all of the corporate formalities like you do with a corporation to get the limited liability. So that's why limited liability companies for smaller businesses are becoming much more popular. But with your limited liability company, again, you still want to provide for structure. And your operating agreement is very similar to the bylaws for a corporation. But with your operating agreement, again, it's going to provide for structures and rules of the company, and it's going to specify what the members' rights are. And your members in a limited liability company are equivalent to the shareholders of a corporation. So what are the members' rights? Capital contributions, those are the contributions that the shareholders make into the company. And when do those have to be made? When are they required? Can a member just put money in anytime they want, or are there certain restrictions on that? And then what if a member does not contribute when they're supposed to? What's going to happen there? And again, these capital contributions in a limited liability company are important, particularly if you're electing to be taxed as a partnership, because your capital contributions affects the taxes that you would pay. So it's important to make sure that all the members understand what their rights are with the capital contributions. Your operating agreement will also address management issues. So for example, the limited liability company can choose to have its management by its members, the same people that own it, so you don't have like a separate board of directors. Or the limited liability company can have a separate management board. And so how are those people voted upon? How long do they serve? What are their rights? What are their duties? And what decisions can management not make without the approval of the members? So all of that needs to be stated in the operating agreement. The division of profit and losses. Again, if you're taxed as a partnership, those rules are determined by the partners. So you could have your division, for example, pro rata, or you can have them disproportionate as long as they meet certain IRS rules. But again, all of that would need to be spelled out in the operating agreement so that everyone understands under what terms they are joining the business. Then your membership units, those are like your shares in a corporation. But what rights attach to the membership units? Are they voting? Are they non-voting? Is it one vote per unit? What sort of profit rights do the units have? So all of that needs to be, again, explained in the operating agreement. The tax provisions. In your operating agreement, it will typically state and name somebody that's specific, what they call a tax matters partner or a tax matter member, and that's the person that basically would be responsible for signing the tax returns and handling any IRS inquiries as it relates to the company. Okay. Your operating agreement should also state if there's any restrictions, just like the shares. can you sell your membership units to anyone, or are those restricted to specific people? When can you transfer, if you can transfer at all? And then sometimes we'll see limited liability companies have their buy-sell provisions right in the operating agreement. Other times we will see a separate buy-sell agreement. And we'll talk about buy-sell agreements a little bit later, but basically what that is it is an agreement or an arrangement where if somebody wants to leave or somebody needs to leave the company, what happens to their membership units or shares when they leave? How do they get bought back? Accounting, again, because this does have a lot of flexibility, what is the accounting methods that are going to be used for this company? Again, you would want to state that in your operating agreement. Your operating agreement would also provide how you can admit new members. When you admit new members, if they're going to be full members with full voting rights, or if they're just going to be assignees, which would just have the value rights associated with the units. How can people withdraw from the company? Can they just walk away from the company if things aren't going well? Can they just walk away, or do they still have rights and obligations to the company? So there needs to be a whole process on how people can withdraw from the company. And then finally, under what terms can the company dissolve? What happens when you're winding up? How are the profits and losses allocated? And the final liquidation. So you can see that because there is a lot of flexibility with a limited liability company, your operating agreement becomes much more important in making a lot of these decisions. Okay, any questions?
I don't have any questions.
Okay.
Okay.
All right, so let's move on then for partnerships. So like a limited liability company, a partnership, again, is very flexible. If you're looking at what type of choice of entity has the most rules, it's a corporation. There's a long history, case law, statutory authority that kind of sets forth the rules of how corporation looks and acts. With your limited liability company, your partnership, it's much more flexible. And as such, then a lot of the decisions fall upon the business owners to use this flexibility, but to, again, for liability protection against partner issues, you want to make sure that your agreement spells everything out. So with your partnership, particularly if it's a limited partnership, you want to be clear as to who's the general partner and who's the limited partner. And from the legal standpoint, this is critical because your general partner has all the liability. They are going to be personally liable for the partnership activities. Your limited partners have limited liability. And again, you want to specify that they do have this limited liability, and you want to identify who are the limited partners so that it's clear, at least on its face, and you can have a document that you can point to saying, no, I signed on as a limited partner.
Question, if I may.
Sure.
Can you specify specifically the limitations on that liability?
Can you give me an example?
Just in terms of repercussions from lawsuits or that, I mean, can you?
Well, I can tell you, I mean, what I typically see in limited partnership agreements with respect to limited partners is that they are only liable to the extent of their investment in the business.
Okay, and the cap on it based on that.
And it ends there.
Okay.
Right. Your general partners are basically open to everything.
And that's like a fiduciary. It extends to personal.
That's right. Right.
Mary, I have a quick question too. Is it always preferable to have a general and a limited partner, or can you have two general partners? Or I mean, you should you have a general and a limited? I guess is the question.
Yeah, it depends what type of partnership you're setting up. You can set up a general partnership, or you can set up a limited partnership. So it depends what you're looking for. A limited partner, because you have that limited liability, you have no rights or say-so in the management of the business. So if you have silent investors, for example, or limited partnerships are commonly used in family estate planning for real estate, for example. Your limited partners are just going to be the silent partners, basically people putting money in that maybe want to get a return on their investment but don't want to run the business, or it's going to be children in a family situation receiving partnership gifts from their parents. But if you want to have the say-so in the business, and when you want to run, if you want to run the business, two people or more, then you would both be general partners. But I can't think of an instance of where I would recommend a company operate as a general partnership.
Okay. Is it almost as much a function of a level of investment in the company as anything else, generally, or the amount of ownership that you have?
As far as the limited partners?
Yeah, or the general partners. The general partner is generally the largest shareholder, generally speaking, I guess.
It doesn't have to be.
Okay.
It doesn't have to be. It's the one that's really running the business.
Okay. Okay.
But if you have multiple people that are going to be working in the business, then I would structure that either as a limited liability company or a corporation so that you have some liability protection.
Gotcha. Okay.
I wouldn't structure it as a general partnership, because then you're just opening yourselves up for too much personal exposure.
Okay. Makes sense. Thank you.
Okay. All right. But with the partnership, so then your agreement would also obviously acknowledge the formation that you are operating as a partnership. It would specify the business purpose for the partnership. It would also specify the capital contributions, again, when they're required to be made, when they can be made, what if the partners don't make them. It will also state the partnership units, what rights are associated with those units, the allocation of profit and losses, just like the limited liability company. Is that going to be pro rata, or are we going to do that disproportionate, which, as long as it satisfies the tax rules, can be done. Your partnership agreement, again, is going to state the rights of the general partner, which is basically full management. It's going to state the rights of the limited partner, which is no management. The transfer of units, if that's going to be restricted, who it can be transferred to, if there's any permitted individuals that those can be transferred to, or if just any third party can do it. Your agreement should also provide for what's going to happen to a partnership units if they need to file bankruptcy, if they die, become disabled, or if it's a corporate partner, if they become dissolved. And the reason here that you want to be very clear about this is so that you're not going into business or becoming partners with people that you don't know. So whether it's spouses, children, or even creditors, you don't want to be in business and working for these folks that you never really agreed to be in business with. So it's important that you specify what's going to happen upon these events. Your partnership agreement will also state which accounting methods you're going to employ, and will also have tax provisions as well. Your partnership agreement will state when and how the agreement can be amended. For example, if all partners need to sign on it, including the limited partners, or whether it can be amended just by the general partner. And then your partnership agreement will also state upon the terms that it can dissolve and liquidate. Okay, that's your partnership agreement. If we move over to annual meeting minutes, again, part of what you want to accomplish here with your legal documents is that you want to afford protection and liability protection for the company. So, for example, if you're a corporation, it's important that you look and act like a corporation. So even if you're a corporation of one shareholder and one director, you still want to document your meeting minutes. And those can be in writing without a meeting, but at least on an annual basis, you should be doing minutes so that you look and act like a corporation. A limited liability company, there's no requirement to have annual meeting minutes. However, it is just good company practice that at least the management have annual minutes just to document some significant decisions that they have made throughout the year. So whether it's a major purchase, whether it's just acknowledging the continuation of the management, you want to have some documentation showing that you are acting as a company and just not individuals. So your meeting minutes, generally you want to document decisions and make sure that you look and act like a company. Again, you want to provide yourself with legitimacy, that you are a company, and also that you're making sure that you have protection against liability. Okay. Some specific agreements that a company should consider as they're getting up and running are confidentiality agreements. And what is a confidentiality agreement? It is an agreement whereby a person signs it agreeing to keep the company's confidential information confidential. And so what is confidential under Ohio law? It can include trade secrets, customer lists, records, customer information, price lists, pricing policies, financial plans. Again, any information that the company has spent time and money on developing, you want to protect. Because what you don't want to have is you don't want to have employees or even consultants come in, see what you've done, take your information, and then use it to their advantage. You want to protect yourself against all that. Okay. And again, on the slide, I just gave you a listing of what is confidential. But again, depending upon your company needs, you can obviously expand that as you see fit. So who should sign a confidentiality agreement? You should consider anyone that has access to the company's confidential information. This would be employees, independent contractors, and consultants. So again, just don't think of it's just the employees that you want to make sure hold your information confidential, but it can also be people that are coming into your business that are not necessarily your employees. And then what time period should the agreement cover? Obviously during the employment or the engagement, and then thereafter. So just because somebody's engagement or employment with you terminates doesn't mean that they're free to start using your confidential information. That should just continue on. The agreement should also cover any product or works created while the individual is employed. So if somebody's working for you as an employee or even as an independent contractor and you're paying them to create a new process, for example, that process belongs to the company because you have paid for their time and for their ingenuity to create that. And so that is the company confidential information which should be protected per a confidentiality agreement. So again, I consider the confidentiality agreement one of the most important agreements for companies, particularly ones that rely heavily on their employees or their independent contractors know how to provide them with the products or with the services or the information. Okay. In addition to confidentiality agreements for employees, you may also want to consider employment agreements. And your employment agreements should be considered for key important employees. So you don't necessarily need employment agreements for every employee that you have. This, again, should be for key people that are vital to your particular business. And so what are some of the things that should be in an employment agreement? It should obviously state the term. Is this going to be a year-to-year contract? Is it going to be a 3-year contract, 5-year contract? That should be specified. What is the salary of the employee? What is the bonus? Is there going to be a bonus program? Is there a bonus formula? That should all be spelled out. What fringe benefits is the company going to provide the employee? Again, that should be spelled out. You know, is there medical insurance? Is there retirement? Is there a car? Is there a spending allowance for that employee? If there's continuing education needed, are you going to provide them with the funds to go to seminars or trade shows? So all of that should be spelled out in the employment agreement. The employment agreement should also specify, at least initially, what the employee's duties and obligations are, so there's a clear understanding of what they're being hired to do. And if the job requires their full-time efforts, then you would want to specify that in the agreement as well. Okay. The employment agreement should also provide termination provisions. So for example, in Ohio, employees can be hired at will. So even though you have the agreement, is it still an at-will relationship? And if that's the case, you would want to state that. If you're modifying the at-will employment arrangement, then under what reasons can they be terminated? Is any reason, but you're going to provide them with notice? Is there for-cause reasons? What are the for-cause reasons? So you want to spell all that out. And then in your employment agreement, you can also specify the confidentiality provision. So they would not necessarily need to sign a confidentiality agreement and an employment agreement. The confidentiality piece can be rolled into the employment agreement. And the same thing with the non-compete. That can be rolled into the employment agreement as well. And what is a non-compete agreement? That is actually the next item we can talk about. It is either part of an employment agreement or it can be separate and apart from the employment agreement altogether. And basically a non-compete agreement is an agreement whereby the employee agrees during the employment and for a specified time period following the termination of employment, they are restricted from competing with the company regarding a product, service, or business activity. So again, what you're doing is you're trying to preserve your company value and prohibiting somebody from setting up a competing shop down the road from you. It's basically the purpose of a non-compete agreement. So your non-compete agreement, what you want to do is you want to be able to specify the time limits. And generally for Ohio, about 2 years is what I've seen courts have been open to. I haven't really seen anything past 2 years. You also want to specify the geographic limits of the non-compete. So if your company's main market is Northeast Ohio, then you would want to specify that they cannot compete with you in Northeast Ohio. You would not want to say they cannot, go across country and open up a business because that's not really your market, and that's not you're not really protecting yourself. You're really restricting them from getting a job. So the courts won't necessarily allow you to be overexpansive in your non-competes. You want to be very specific and make sure that you're just protecting your company. Your non-compete, you also want to prohibit solicitation of customers, so you want to make sure that they don't go after your existing customers. You also want to make sure that they don't solicit any of your employees away. Okay, and what are some of the things that you would want them to restrict them from doing? Well, ways that they can compete is they could own joint ownership with the company. They could work for another company, a competitor. They can consult for the competitor, or they could establish a new company. So again, those are all the ways in your non-compete agreement that you want to make clear that these are the types of things that you cannot do. And again, what you're trying to do is to protect company value. You want to protect what you have and not allow people to compete and steal your customers or your employees away. Okay. Want to move over next to a buy-sell agreement. And what is a buy-sell agreement? A buy-sell agreement becomes important when you have more than one owner in a business. And the purpose of the buy-sell agreement is that it's going to specify upon certain events when your shares are going to be bought out. Most of the companies are closely held businesses where the owners are the ones that are intimately involved with the company. And so, for example, if somebody were to die or become disabled, if they can no longer contribute to the company, you would want to buy their shares back so that you're not involved with family members of that person in the business who may have no idea about the business, no idea how to run the business. You really want to make sure that you're in business with people that you know and that you want to be in business with, and not through some event, whether it's death, disability, retirement, all of a sudden you become business partners with somebody that you choose not to be in business with. So very basically, your buy-sell agreement is going to be an agreement. It can either be an agreement where the shareholders would agree to purchase each other's shares upon specified events, or it can be more of a redemption agreement where the corporation agrees to redeem, buy back the shares from a shareholder upon a specified event. Or your buy-sell agreement could be a combination of shareholders buying and a corporate redemption, or as an option. So there are a lot of possibilities here. And again, the purpose is to maintain ownership with the people that you initially started the business with or want to be in business with. So what are some of the triggering events that would cause someone to buy your shares or to redeem your shares? Some of the possibilities, again, and you can tailor this to your business and to your specific needs. These are just suggestions here. But one possibility is at retirement, and you can define retirement however you like. Death, disability, termination of employment, or just election to transfer. And I put election to transfer in here because as some people may be nearing retirement, maybe they don't want to own the shares, but they still want to work for the company. That would be an example of election to transfer. So then once you have one of these events, then what happens? Who is going to purchase? Who's going to buy those? Again, it can be the remaining shareholders, it can be the corporation redeeming, or it can be other permitted transfers. So examples of other permitted transfers could be existing key employees that possibly you could name in the document or to be named later in the document. If you have family members that are active in the business, for example, your business partner's son, you may allow them to be a permitted transfer. So it doesn't necessarily have to be the remaining shareholders or the corporation. It can be other identified people in your document.
Mary?
Yes.
On the other permitted transfers, does that have to be specific, or could that be a general category?
Whatever the parties would agree.
Approved, approved key employees, but non-named.
Sure. As long as all parties agree to it and sign off on it, sure. And then you would just want to make sure so that you don't have a fight down the road.
Right.
How it's identified. Who has to agree to who is that later named key employee? Do all shareholders have to, or all, current shareholders and the seller, or is it just the current shareholders, not the seller, type of thing?
Okay.
So you just want, as long as you spell it out, that would work.
Thank you.
Okay. And then price. How is the price going to be determined? Are you going to set a price? And if you set a price, then you just want to be careful that the buy-sell agreement is reviewed each year, because you don't want to put this in place and say that the price is $1,000 per share, but then 10 years from now, when the company's grown, exponentially, that set price doesn't really reflect the fair market value. So if you choose a set price, you want to make sure you review that annually. Price can be determined by appraisal, whether that's one appraiser, two appraisers, three appraisers. And then if you do that, you just want to outline what the parameters are of how the appraiser will make the appraisal. You can have a formula in there. Is it EBITDA or is it book value? You can put a formula in there. So again, whatever the parties want to agree to, they can have the price determined. The payment terms. Once you have the price and you're being bought out, how are you going to be paid? Is that going to be lump sum? Is it going to be installments? So again, you would want that all spelled out. If it's typically, what I find is that if the triggering event is death and the shareholder was able to get life insurance to cover some of this cost, then I will see an immediate payment of insurance and then the balance paid out over time. I want all of this spelled out. To the extent that there's any money or loans owed to the corporation, is there a right of set-off by the corporation? You would want to spell that out as well. You would also want to spell out when payments would commence. So for example, after the triggering event, after the price has been determined, are payments going to begin 30 days thereafter, 90 days thereafter, a year thereafter? You want to specify when all these payments are going to start. And if there's installments, what is the interest rate, or how is the interest rate going to be determined? Is there going to be any security given to that selling shareholder or the selling shareholder's family members? And will there be any restriction on what the company can pay until the shareholder is paid off? For example, if you're looking at it from the shareholder's point of view, you do not want extraordinary bonuses paid out, taking all the value out of the company until you've been paid off in full. So you want to address some of those issues as well.
What if, quick question, Mary, on that bonus situation. If there is a legitimate bonus plan in the company's minutes and even employment agreements, can those continue, or can a buy-sell like this force that those not be paid?
Well, it depends what your buy-sell provisions provide. I mean, if your buy-sell provision is silent and doesn't state anything as far as what the company is restricted from paying during this time period, then you can pay anything. If you're doing a buy-sell agreement, you would want to make exceptions that any restriction, you would want to limit the restriction to any extraordinary expenses that are not in the normal course of business or not part of the normal business practices.
Okay, thank you.
Okay. Also, your buy-sell agreement should also consider the fact that, particularly if somebody terminates employment or they just elect to transfer and then terminate later, that if you're doing installment payments, you can stop the payments if they start competing with the company. Because again, you don't want to fund somebody from taking business away from you and competing with you. So you would want a provision in there that if they compete with you, you can stop any payments to them. Same would hold true if they disclose confidential information. Again, they're harming the company. You don't want to pay them or reward them for harming the company. A lot of times you'll see in buy-sell agreements where the corporation will use their best efforts and try to release that selling shareholder from any personal obligations. So if they personally signed on some company loans, that the corporation would try and get their names off of those personal obligations. Again, whether or not we're successful doing that, at least the company can show some effort trying to do that. Your buy-sell agreement will also have, obviously, non-disclosure provisions to protect the company's confidential information. If your company is an S corporation, which is a special tax status, then what you would want to do is put some provisions in there about closing the books as of the date of sale, make distributions so that the shareholders can pay their taxes, and then make sure whoever is the new shareholder is a permitted shareholder so that they don't violate the S corporation status or election. Okay, and with that, that's everything that I have prepared. But I think with these general guidelines and some of these general legal documents that we just touched upon, if you look at these documents and use a couple of these documents in your business, that you will be well on your way to protecting the company value and the resources.
Mary, I have a quick question, looping back to the LLC question. In terms of the number of members or participants in the LLC, is there number one, is there a limit to the number of members in an LLC? And do you see a typical number in the deals that you're putting together of LLC members?
With the LLC, there is no number limit on the LLC, unless you're an LLC electing S status. If you're an LLC electing S status, then your S rules apply. So you want to be careful as to what sort of LLC, from a tax standpoint, you want to be. But if you're just a regular LLC electing partnership status, for example, you can have any number of members in that LLC, and they can be of any variety. So I've seen LLCs where it's a grouping of other corporations, for example, or a combination of corporations and trusts or individuals. But if you're S, if you're an LLC taxed as an S, you would need to conform to the S rules, which means individuals, no corporations, no more than 100 total. For closely held businesses, which is really what I work with, when we're looking at members for an active LLC, we're seeing no more than 10 to 15 at the most.
Okay. All right. Thank you.
Thank you, Mary. I want to thank you for the excellent presentation. One of the hallmarks, I think, of a good presentation are explaining complicated concepts in a manner in which everyone can understand, and that's something I'm very appreciative of, personally, even. Also, I wanted to, it's kind of like a closing statement, similar to what Mary said. We often get questions when we talk to business owners, and we start asking them these questions. Do you have a bunch of the documents in place that Mary talked about here? And they often ask us, what does that have to do necessarily with succession planning? And I think the key for us is, and Mary, you can feel free to agree or disagree, but when you have these things in place, it creates a well-functioning company. that it creates value in that company. It creates a company that's is valued by potential outside buyers. It creates a system in which you have the basics taken care of, and then you can focus on creating, increasing sales, increasing market share, moving into different markets, whatever it might be you need to do to keep your business moving. And these documents help you get the basics out of the way, so to speak, and focus on the important parts in your company. So, Mary, I don't know. I'm assuming I'm not too far off base there.
No, I would echo everything that you just said. I think if you're looking at it from a succession standpoint, you've laid the groundwork. The groundwork is there. You're going to have a good, solid foundation for somebody to be able to step in and take over. So whether that is somebody from within or whether it's from somebody buying, they want to look at how are you structured. Have you been running this as a good, solid company with certain practices, procedures? You know, do you have, if I'm looking at buying you or even succeeding, do you have your key people lined up? Are they on board? Do you have the non-competes? Do you have the confidentiality agreements? Or is that something I'm going to have to start over with? And then that's going to take away from my transition time to do all of this. So it is, not only is it good corporate practice to have these things, but it also lends and makes it much easier for that succession and transition time to take place because you're not worried about the basics. The basics are done. You're worried more about the transition and getting it transitioned over.
I agree wholeheartedly.